Hi, my name is Natalia and I'm a real estate attorney here in the state of Florida. And today I want to talk to you about, and this is targeted at foreclosure lenders, what if the borrower files for bankruptcy? So I've done a video before regarding bankruptcy filings if you are a third-party bidder at foreclosure auctions. Today's video is tailored to private lenders who have opened up foreclosure proceedings and where the borrower has filed for bankruptcy at any time along the case. So in the event that your borrower or one of the borrowers decides to file for bankruptcy, what happens? Well, the first thing that happens is that it triggers an automatic stay if it is the first or second time that they're filing for bankruptcy in the case. And so what that means is that you cannot do anything, or your attorney during the foreclosure can't do anything in those proceedings to move the case along once a notice of bankruptcy is filed. Everything is stayed, it's stopped, it's paused. And so at that point, you can use your counsel that's been doing the foreclosure proceedings to appear on your behalf and file a claim for you as a creditor in the bankruptcy proceedings. Or if there is another counsel that you like to regularly use to represent you in the bankruptcy court for those foreclosure matters, then this would be the time for them to appear and file that notice of claim. In the bankruptcy proceedings, there's a creditors meeting, and depending on the type of bankruptcy that they have filed, which could be a Chapter 7 type of bankruptcy where they just want to be discharged of personal liability. It could be a Chapter 13 one, which involves an attempt to come up with a plan for repayment during a 3-year or a 5-year period. So you just have to see what happens in those proceedings. If they file for a Chapter 13 plan and the plan seems feasible, it seems like it's workable within their income to pay back what they've been delinquent through date, then the court will likely approve that plan and you will be repaid through the bankruptcy process for that delinquent amount. But this does not mean that you're going to get paid back what is remaining on the loan. Like, it's not, because when you file a foreclosure auction, what essentially you're saying is that you're calling the whole thing due and payable. Bankruptcy works a little differently. So what the repayment plan is doing is how to repay back in 3 years or 5 years what they've been delinquent through the date of filing, not that whole amount that you've claimed due and payable through the foreclosure. So just be aware of that. If they are not able to meet a plan that works, satisfy the requirements set out by the trustee and the other creditors, then it is likely that the case will be dismissed and then it gets sent back to the foreclosure court. When there's an order of dismissal, there's still a 14-day stay where no activity can take place. Once that time period has passed, so then your attorney can restart working on the case. Now, it's important to know that if they have filed bankruptcy for the 3rd time in your case, so they're just routinely trying to halt proceedings, that 3rd time is going to be seen or taken as a bad faith filing. There is not going to be an automatic stay of the proceedings, and your attorney will be able to continue to do the case while that bankruptcy is being examined by the bankruptcy court. So that is my little summary for you private lenders out there. If you dare to foreclose on property and experience one or more of the borrowers filing for bankruptcy protection. My name is Natalia I'm a real estate attorney. As always, I wish you investors good luck out there.